This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why there is no restitution available from a defrauded insurer, because fraud in the inception of a policy is a mandatory, if not at least a necessary ground for rescission. Esurance Property and Casualty Insurance Company appealed the trial court's order granting summary disposition in favor of Nationwide Mutual Fire Insurance Company and denying Esurance's request for summary disposition. In Nationwide versus Esurance, a June 15, 2023 decision of the Michigan Court of Appeals, Esurance alleged its insured defrauded it when it acquired the policy, and it was entitled to rescind the policy regardless of the trial court's balancing of equities. In 2015, Derek Gregory was driving a truck insured by Esurance and co-owned by his wife, Blair Gregory. The truck collided with Daniel Moore, who was riding a bicycle. Moore was injured in the accident and was uninsured, and his claim for personal protection insurance benefits was assigned to Nationwide via the Michigan Automobile Insurance Placement Facility. Nationwide paid a total of $454,871.09 in medical expenses on behalf of Moore. Nationwide subsequently sued Esurance and Moore, seeking to recover the PIP benefits it paid on Moore's behalf. Nationwide alleged that Esurance, as the insurer of the truck, was in a higher priority position and was required to reimburse Nationwide. Esurance subsequently filed a third-party complaint against Nationwide and the Gregorys, alleging that Blair had failed to disclose several material facts in her application for the insurance policy, including that she was married, that Derek occasionally drove the truck, that Derek had been in a prior accident involving alcohol, that Blair had been involved in prior accidents, and that Blair had filed prior claims with other insurance providers. Esurance argued that Blair's misrepresentations in her insurance application constituted fraud, warranted rescission of the policy, and prohibited Nationwide from recovering from Esurance as a higher priority insurer. After a hearing on Nationwide's motion, the trial court issued a written opinion granting summary disposition in favor of Nationwide. The trial court noted that rescission is not automatically applicable in the face of fraud. The trial court held that Esurance had failed to show that rescission was warranted and that Nationwide could stand in Moore's shoes and recover from Esurance on the basis of equitable subrogation. Esurance argued that the trial court erred by granting summary disposition to Nationwide. Specifically, Esurance contended that the trial court abused its discretion in concluding that the balance of the equities weighed against rescission. Equitable subrogation is a flexible, elastic doctrine of equity that is decided on a case-by-case basis. Equitable subrogation is the mode which equity adopts to compel the ultimate payment of a debt by one who, in justice, equity, and good conscience, ought to pay it. The Michigan Supreme Court has held that the plain language of the No-Fault Act does not preclude or otherwise limit an insurer's ability to rescind a policy on the basis of fraud. Although PIP benefits are mandated by statute, the No-Fault Act neither prohibits an insurer from invoking the common law defense of fraud, nor limits or narrows the remedy of rescission. However, the presence of fraud by the insured does not automatically entitle an insured to rescission. when innocent parties are affected, rescission is left to the trial court's discretion. Rescission should not be granted in cases where the result thus obtained would be unjust or inequitable, or in cases where the circumstances of the challenged transaction make rescission infeasible. There is no dispute that Esurance is an innocent insurer and that Moore is an innocent third party. Case law in Michigan clearly demonstrates that the equities must be balanced between the insured person, the injured person, and the party seeking rescission. The Michigan Supreme Court already rejected Esurance's argument in another case and held that such insurers may be reimbursed via equitable subrogation for PIP benefits paid on behalf of an uninsured person. There was no evidence presented demonstrating that Esurance knew about the fraud before Moore was injured, and there was no showing of how Esurance could have been more diligent in reviewing the insurance application or in detecting the fraud. A determination of whether policy enforcement only serves to relieve the fraudulent insured of what would otherwise be the fraudulent insured's personal liability to the innocent third party. In totality, the court concluded that the trial court abused its discretion by holding that Esurance had failed to show that rescission was warranted. The ultimate issue in innocent third-party cases in which innocent party should bear the ultimate burden of the insured's fraud. In this case, Moore has already recovered benefits from an alternate source, and rescission will have no effect on that coverage. In other words, if the policy is rescinded, neither Esurance nor Moore would, in practical terms, bear the burden of Blair's fraud. Under these circumstances, the trial court's decision to deny rescission fell outside the range of principled outcomes. The trial court was ordered, therefore, to grant summary judgment in favor of Esurance. In my opinion, no one should profit from fraud, not even an innocent insurer that paid benefits under a no-fault insurance scheme, since it would have had to pay even if there was no insurance on the other side. Esurance was entitled to rescind because it would never have insured the Gregorys but for the fraud in the inception of the policy. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you found this video to be useful, please tell your friends and colleagues about the blog and the videos, and let them subscribe to the blog and the videos, which are all available free to anyone who asks. And if you do watch the videos, please click on the like button and or the thumbs up button on Rumble, and please also consider subscribing for a very small fee to my Locals community and my Substack publications, where more detailed and extensive information about insurance, insurance law, insurance claims, and insurance fraud can be found. Thank you for your attention.